Good morning, everyone. Welcome to today's session. We are joining this meeting today. So, without any waste of time, constitution was the business.
Results for today, 7th day of February 2023. We have just a case before you, and that is the case of Armed Forces of Nigeria against N5759 Seaman Abbas Aruna.
Okay, bring in the activities. Defense Council, are you ready for the business of today?
Sorry.
Accused, what's my response to this? I should read it again. Now listen again. This is an insinuation from the defense counsel that the accused is saying that he does not understand the last charge, the last count charge. The last count charge read to him. It will be for the interest of justice for the accused to actually inform the court whether he understands or does not understand. If actually he does not understand, that means that it is the responsibility of the JA to also read it again to him. If it requires explanation, he can as well explain. So when we want to hear from the accused person, if you don't understand, tell the court that you don't understand. Because you can only take your plea on a charge that you understand. Are you hearing me?
Yes, sir.
So, having read this count 3 to you, tell this court, do you understand the charge or should I read it again that you don't understand? You understand the charge?
Yes, sir.
Okay. Having informed the court that you understand the charge, how do you plead? Guilty or not guilty on that charge? They are giving you another leverage, another time, another opportunity to make your plea. Because this is a proceedings for change of plea. If actually you want to change your plea in this charge, you have told the court you understand the charge. Is it not?
Yes, sir.
How do you plead to this charge? Guilty or not guilty?
Guilty, sir. Should never justice be necessary.
Okay. Thank you. Your Lordships, distinguished members of this Honorable General Commission, the charge has once again been read to the accused person. 3 count charges read to the accused persons. And in line with the proceedings for change of plea, that's happened. That's to enable him to change his plea. He has successfully pleaded guilty to the 3 count charges. is now there for the court to deliberate, and as well to go deliberate on the change of plea of the accused person, and as well having studied the countenance of the accused person, his demeanor in the process, in the proceedings of change of plea, should be able to determine whether to accept the plea of change of plea that he made or not. It boils down to the court in line with the rules of procedure. I humbly request the court to go for deliberation and as well come back to inform the court whether they will accept the change of plea or not. Prosecution, do you have anything to say?
Just for record purpose, and to be seen as justice is not only done, but is manifestly done. My lords, reading through that's Naval court-martial's procedure for Royal Navy, the provisions is similar to what are obtained in the rules of procedure army. They need to explain to the accused person the implication of his plea of guilty, the likely punishments that are waiting, and the fact that the court will go ahead to enter even the maximum punishment provided in the Armed Forces Act. And the procedure, although I think it's fairly important that these are explained on record to the accused person before the court will try to deliberate and to come up with a decision whether to accept the pleas or not. That's my humble observation.
Defense, any response to that?
Yes, my learned senior has said it all. To have the record straight. That is what the rule says. In the rule of the court, I don't think we have to exercise discretion. So let's exhaust it. That's our humble observation.
At this point, the accused person has actually pleaded to the 3 counts charge. It is incumbent on the judge advocate, in line with the rules of procedure, Royal Navy DR 11, which is synonymous to that of rules of procedure Army 1972. It states that whenever the accused person pleads to the charge, guilty to the charge, it is the responsibility and incumbent on the judge advocate to explain the implication of his change of plea. The implication of his change of plea, and again the discretion of the court to go ahead and enter judgment in line with his plea of guilty. The accused, now I'm addressing you. You have made a change of plea to the 3 count charges which was read to you. It implies that you have given the court, you have asked the court to go ahead and deliberate on whether to accept the plea on the ground that they have the power to go ahead as well to punish, enter any judgment. The implication is that you have submitted yourself for judgment. You are asking the court to enter any judgment, even when the court decides to enter the maximum judgment against you, that it is what you have accepted by faith. And of course, the court has the discretion as well to put into consideration the fact that we have all as well pleaded guilty to those offenses. So the court will go for deliberation, and when they come, as well, they will as well consider to accept or not to accept. Where the court accepts their plea, their change of plea of guilty, they will enter judgment, and whatever they enter as a judgment, you accept it because you have pleaded guilty to the all count charges. When the court refuses to accept, it means that they are going to go for full trial, and it is now the onus will now be shifted to the prosecution to call their witnesses. And the implication is that they are going to go for full trial, and when they go for full trial, they will call their witnesses to testify against them. And when they do not go for full trial, it means the court has the power to enter judgment, and that's you will have to bear the liability of the punishment. Do you understand? The court should go ahead and deliberate and come back that you are accepting, you have agreed as you pleaded guilty to the 3 count charges. Now you are not in duress, you are not under influence, that it is their wish that you accepted this plea of guilty that you pleaded on the 3 count charges.
Yes, sir.
Thank you. The Lordship is now for the court to go to inner chambers for further deliberation and to come out with a conclusion on whether to accept the plea of guilty or not. Please proceed, Lordship. Thank you.
All right. At this point, the court will rise to go and deliberate on the accused written change of plea. When we return, we'll give our ruling. Arise. Let's have a prayer song.
Beloved, with profound respect and humility, we remit Major J. O. Captain N.P. Seaman, and Captain N.E. Oku for the prosecution.
And my novel was be placed, Chuku and Abbas. For the defense, and all my learned friend will soon be joining us.
Where is he? Is your friend or your colleague?
No, it's not very difficult.
Okay, without much more time, go straight to the word of punishment. A word of punishment by this General Court Martial in the case of Armed Forces of Nigeria versus M5159 Seaman Abbas Haruna. The accused rating was charged on 3 count charges of disobedience to particular orders, resistance to arrest, an offense in relation to public and service property, contrary to Section 56 of Section 1, Section 86 of Section 1, and Section 66 of Section C, respectively, of the Armed Forces Act Cap 820 Law of Federation of Nigeria 2004. The accused rating was earlier arraigned before the court and he pleaded not guilty to the 3 count charges. However, the defense counsel made an application in line with the rules of procedure Royal Navy BR 11, which is in consonance with the rule of procedure Army 1972, to this court to enable the accused rating change his plea. The application was not opposed by the prosecution counsel on the ground that it is the right of the accused rating to change his plea anytime during the proceeding before judgment. The accused rating pleaded guilty to the 3 count charges, and his plea of guilty were duly accepted by this court. The prosecution thereafter availed this court with the summary and abstract of evidence. The prosecution further tendered 7 documents as exhibits in this case. The defense, however, did not object to all of the documents, and they were admitted in evidence and marked as exhibits A to G. The accused rating himself made a plea of mitigation of punishment. He personally appealed to this court to temper justice with mercy. Thereafter, the defense counsel submitted that the accused rating may have committed the offense as a result of his inexperience in service, looking at the number of years he spent in service, which was nearly 4 years as at the time of the commission of the offense. He further pleaded with the court to consider the adverse effect of the punishment to be awarded to the accused rating by this court. However, in all of the submissions of the defense counsel in his plea of mitigation, this court consistently observed that the countenance of the accused rating is more of unremorseful and unapologetic. The accused rating attitude of disobedience to lawful authority, which was indeed similar to one of the count charges which he faced in this criminal trial, continued to manifest even while the procedure was ongoing. It is therefore out of the principle of justice and fair trial that this court accepted the accused rating change of plea. However, this court will not be deterred from ensuring that justice is meted out in this case. One can only imagine the action of the accused rating when he disobeyed the order of a senior officer and yet blatantly resisted arrest and still went as far as expending 16 rounds of 7.62mm special. What agitates the mind of this court is that the action of the accused rating could have resulted in the death of any of his colleagues, which could have occurred from his sporadic shooting. The action of the accused rating is no doubt an act of gross indiscipline, capable of taking the lives of his colleagues. It is now evident that the accused rating, by his action, can never be trusted with rifle in the armed forces of Nigeria. And if so, it therefore means that as a rating in the Nigerian Navy, who cannot be entrusted with rifle, there is no doubt that he will not be useful to the Nigerian Navy and indeed the armed forces of Nigeria anymore, since soldiers, rating and aircraft mate are trained for the purpose of weapon handling and judicial applications when called upon for the protection of the sovereignty of the Federal Republic of Nigeria. Consequently, this General Court Martial find the accused rating guilty on the 3-count charges as he earlier pleaded. This court thereby sentenced M5759 Seaman Abbas as follows. Count 1 on disobedience to particular orders, reduction in rank from seaman to ordinary seaman. Count 2 on resistance to arrest, dismissal with enormity from the armed forces. Count 3 on offense in relation to the public and service property, dismissal with enormity from the armed forces. However, counts 2 and 3 shall run concurrently. This judgment is, however, subject to confirmation by the appropriate superior authority. This judgment is dated this 7th February 2022.
We shall not bet thank your industry and your magnanimity, even though in your sentence. We say we are very grateful, and may the Almighty continue to guide you as you continue your other deliberations. That's our appreciation.
The prosecution.
My Lord, we very much appreciate the court for the industry and the well-balanced judgment and sentence. It will go a long way to send a message, strong one, to any other would-be offender. My Lord, on this note, we want to most respectfully announce that that's the end, the only case, at the end of the cases we brought before this General Court Martial for today and for the time being, and maybe subject to the overriding decision of the conferring authority, the court may adjourn sine die. Thank you, my Lord.
Okay, having to tell cases that are presented before this court for the time being. This court is hereby joined indefinitely. So I rise.